Are you unfamiliar with forced arbitration? If so, you're not alone. Most Americans have no idea what forced arbitration is. Yet, chances are you agreed to participate in forced arbitration quite a few times in the past. If you started a new cell phone plan, opened up a credit card account, rented a car, or signed an employment contract, you have more likely agreed to take part in forced arbitration. The fine print related to actions like these often features a forced arbitration clause. Or you might be forced to arbitrate a future dispute through a mandatory arbitration clause. Forced and mandatory arbitration are the exact same legal concepts. So, what do they mean? Say that you agreed to forced arbitration by writing your signature on a contract. This means that you have given up your right to sue the other party, such as a company or an employer. But don't despair that you can't file a lawsuit. Instead, now you have every right to pursue legal action through arbitration. And arbitration is the number one alternative to U.S. court litigation. Instead of presenting your case in front of a jury or judge, you and your opposing party will be able to attend an arbitration hearing. The hearing will be presided by either an arbiter or a panel of arbiters. Both parties will have say on which arbiters get chosen to listen to the arguments and examine the evidence. The arbitral process is almost always quicker than resolving an issue in a courtroom. And because arbitrations are so fast, it's often a lot cheaper than going to court. The arbiters will make a final decision on a case, just like a judge in a courtroom. And that decision, unlike a decision rendered in a public court system, it is confidential and final. This means appeals are very limited. And that's good. Why? Because the process of appealing a judge's decision in a litigation can drag on for many years and can cost parties thousands upon thousands of dollars. Here's an example how forced mandatory arbitration works. Say that you're the employee at a major airline, and your company's been making you work many hours of overtime. You then realize your employer owes you over $4,000 in overtime wages. So, you try to file a lawsuit claiming that the airline has committed wage theft. That's when your employer informs you that you signed an arbitration agreement when you joined the company. As a result, you can't file a lawsuit in court, but instead, you can still go to arbitration with or without a lawyer. This situation can be a win-win for you and your employer. That's because arbitration is always almost cheaper and faster than going through years of court litigation. In fact, tons of arbitrated disputes get settled after just one single hearing takes place. Example isn't common? Think again. The Economic Policy Institute recently estimated that about 60 million American workers are subject to forced mandatory arbitration procedures. And that number will continue to grow year after year as more people discover many benefits associated with arbitrating a dispute. Forced arbitration shouldn't discourage you at all from pursuing a valid claim. You or your organization can win an arbitration just like you can in court. And once you win, the monetary award is immediately binding. This means that you and the opposing party can move on with your lives instead of having to appear in court for years to come. Plus, you can overcome just about any legal obstacle through forced or mandatory arbitration, from wage theft to discrimination to predatory banking practices. Forced and mandatory arbitration is continuing to become more popular. If you need help interpreting an arbitration agreement, drafting one, or anything else, do not hesitate to contact our association. You can get in touch with us through our website, arbitrationagreements.org, or you can call us right now, 844-544-0444. Our arbitration experts are standing by to assist you with any process related to mandatory or forced arbitration. We look forward to helping you, your organization, or your party to succeed.